All right. All right, everyone. Welcome to the 187 District Court. Happy Monday. It's going to be happy because we're going to make it happy.
Yes, sir.
And we should also be happy because we survived. I see Michael White still hasn't mastered the mute button, but that's okay. It's still going to be a great Monday. So today is a very important day. And the reason why today is very important is because it's, I believe it's National Court Reporter Week, Brenna. And
Yes,
so, so the mayor is going to do a proclamation. And included in this proclamation is this lovely person here who is the court reporter for the 187 District Court. Court reporters do such great work for us. And if you sit and think about it, the fact that all of us talk at different speeds, some of us mumble, then we get a little bit upset, we start talking over each other, and the court reporter still takes everything down. So, Brenna, thank you for all that you do and all the other court reporters.
Thank you, Judge.
And that being said, they're going to be doing that at 12 p.m. on, I think they're still going to do it live on the courthouse steps, maybe, or maybe it's virtual. But either way, we're going to be recessing at 11:45 so that Brenna will have a chance to log out and go to an event that will honor her. And as a part of honoring her today, when we go on the record, everyone is going to speak clearly, everyone is going to enunciate, and nobody's going to talk over each other. And that's going to be our gift to Brenna on this day. And Brenna, I promise you, I will continue to talk at this speed. I will not speed it up. All right. So everyone, you're in the 187 District Court. These are the rules. You're in a courtroom. Whatever you could not do if you were physically in the courtroom, you cannot do on this Zoom screen. So if you're on bond, you're not to be doing laundry. You're not to be wearing baseball caps. You're not to be running errands, changing diapers. If you do any of those things, and if you behave inappropriately, your Zoom privileges will be revoked. And what that means is that you are going to have to appear in person in the 187 District Court. Courtroom is located at 300 De La Rosa. It's on the 4th floor. So that means you're going to have to get a Lyft or an Uber. If you take the Via bus, which I've taken the Via bus, they still don't give correct change. And when you need correct change, you never have it. So that bus ride may end up costing you $20 when really it's only $2. If you drive downtown, you're going to find a lot of one-ways, you're going to find a lot of construction. And if you're able to be blessed on this day to find a parking space, you're going to find that those parking spaces are very expensive now. If you're at the Bexar County Jail, you're not allowed to use the internet, you're not allowed to use the chat box. If you do any of these things, you're going to end up getting sent back. We'll maybe see you in 60 to 90 days because you know there are staffing issues. I'm going to open the breakout rooms. When I open breakout rooms, it's going to invite everyone to join a breakout room. Do not, I repeat, do not join a breakout room unless you're specifically called and assigned to a breakout room. To all the defendants and those who are accused, you're going to hear your attorney's name called. Your name will not be called. If you do not hear your attorney's name, please be patient. That just means that your attorney is Zooming in another courtroom or had to appear in person in another courtroom. We will do our best to get your attorney here to speak with you. To all the defense attorneys, it will make assigning you to breakout rooms much easier if you would add to your name the name of your client and whether or not it's criminal trial division or family violence. To all attorneys, if you have a plea bargain agreement, no matter how small you think that plea bargain agreement is, it needs to be placed in the chat box to the court coordinator. She's listed as Ferguson coordinator. If your client is on bond, she will need to know your client's email address. Do not text her, chat her, call her, email her, asking her for a continuance. I'm the only person who can do that. To all of the defense attorneys, if you have a client and you speak with your client in the breakout room, you are not allowed to excuse that client. The court, myself, is the only one who can excuse that person and have them done for the day. If you excuse your client who's at the Bexar County Jail, we're going to get them back, but it's going to take a while, and you're going to be on this Zoom longer than anticipated. In just one moment. All right, attorneys, this is the order in which you'll appear. If you see your name is low on the list and you wish to zoom to another courtroom, you're more than welcome to do so. However, you zoom to another courtroom, your name is called, you'll be placed at the end of the list. Lorraine Efron, Nathaniel Navy, Adam Cobbs, Kelly Pittle, Melissa Christian, William Davidson, Michael White, Carissa Tchaikovsky. Is there anyone whose name I have not called? All right.
Barry Hitchings.
All right, thank you, Barry.
If I can be put on with Melissa Christian. We both represent the same defendant.
All right. Okay, when you get to the breakout room, you should thank Melissa for being at the top of the list.
I will, Your Honor.
All right.
And Judge, I'm also present. I believe I have a client in custody.
All right, Ms. Calderola. I'm trying to wrap my tongue around all the syllables for your last name. I'm working on it though. All right, anyone else whose name has not been called? All right, attorneys, when you get assigned to the breakout rooms, think of those breakout rooms as when you go to the doctor's office. When you get on time to the doctor's office and you think hey, they're calling me to the back, I'm on time. They're putting you in a smaller breakout room to check your weight and your blood pressure. So everyone put some patience in your pocket. It's going to be a great day. All right. Let me see. I have another prosecutor zooming in, Villarreal. All right, Lorraine Efron.
Good morning, Judge. I have Alfonso Boterre. His competency has not been resolved yet, but if he's here from the jail, I wouldn't mind speaking with him if he will speak with me.
Okay. I don't see him yet. What I'm going to do is I'm going to send you to breakout room number 1 with Miss Ferguson, or either Miss Ferguson, can you chat Miss Efron and let her know when her client will be on the Zoom, please?
Yeah, I think he's declined to see me before, so.
All right, we'll see
Let's
what's
see.
going on.
Alrighty, thank you.
All right, thank you. All right, and also all the defendants and those who are on this Zoom screen, you are not allowed to let your screen go dark. The only time your screen should go dark is if you're on your phone and if you're signing paperwork. If your screen goes dark, you're going to be required to appear in person. All right, Nathaniel Navy, thank you so much for changing your name.
Good morning, Judge. No problem. I have those 3 individuals. It's all family violence.
All right, I sent you to breakout room number 3. Adam
Thank you.
Cobbs. Who do
Thank
you have?
Judge. I've got two, Jamarian Smith. It should be CTD. It's a drug case, but it appears that a new case has been charged assault of a public servant. So that's probably either CTD or I guess perhaps special crimes.
All right, I'm going to send you to breakout room number 4. Kelly Pittle.
Morning, Judge. Christopher Rodriguez, CTD.
All right, just one second.
Hey, Kelly, Lorraine Efron, congratulations.
Oh, thank you. Appreciate it.
All right, number 5.
Thank you.
Melissa Christian and Barry Hitchens. Melissa, thank you so much for changing your name. I'm going to send you to
Absolutely.
number 6.
Thank
And
you.
I see you have one of my pins on. It's beautiful.
I do. And just so you'll know, the last Piggly Wiggly I remember was basically where Bird Bakery is right now on Broadway. That used to be a Piggly Wiggly.
That is so true. You know, all the Piggly Wigglies are gone.
They are all gone.
All right, I'm going to send you to number 6. And Barry Hitchens, if you'll go to number 6, please.
Thank you, Judge.
You're welcome. Bill Davidson, I'll send you to number 7.
Thank you, Your Honor.
You're welcome. Michael White, who do you have? Michael White. You need to unmute yourself, Mr.
Oh, I'm
White.
sorry, I was muted, Your Honor. I'm sorry. Yeah, my client is Jorma Pettis, and you need a number on that. That is.
Now, is it criminal trial division or family violence?
Yeah, this is DWI, and I need to talk to a prosecutor to confirm the plea bargain offer that he gave us the last time.
I'm going to send you to number 8.
Thank you, Your Honor.
Carissa Chakosky.
Good morning, Judge. I have Igor Olinsky,
Is it criminal trial division or family violence?
family violence.
And I'm sorry, what was the last name?
Olinsky, Ilinski.
And family violence, criminal trial division, I'm sorry.
Family violence.
All right, I'm going to send you to number 9.
Thank you.
You're welcome. Morning. Gail Calderola.
I'm here, Your Honor.
Thank
I have Anhaiso Rivera, and I believe it's family violence. It's an
How do you-
MTR,
How do you spell the first name?
ANJISO.
And the last name, I'm sorry, what was it?
It's Rivera, RIVERA.
And you say family violence?
Yes, yes, sir.
All right, I'm going to send you to breakout room number 10.
Thank you, Your Honor.
You're welcome. All right, the person who has the headphones on, who's listed as Jay, what is your full name, please?
Jamie Soto.
Okay. All right, anyone back from the breakout rooms?
I am Judge Kelly Fiddle.
Okay. All right, Mr. Piddle, what is happening with your case, Mr. Rodriguez?
Judge, we're still waiting on videos. It's my understanding that Marcus has asked his investigator to reach out to SAPD to get those without any luck, so they've gone up the chain.
All right, and where is your client?
That is a good question, Judge. I do not know the answer to that. I've emailed him the Zoom link and reached out to him this morning as well. I've not heard back, but he's never
Right.
missed before.
All right, I give everyone till 10:30, so if you want to zoom out and zoom back in.
Okay, I will do that.
All right, thank you.
All right, thanks.
All right, Adam Cobbs.
Hi, Judge. I conferred with Joe Ray. The assault on a public servant from January 1st of this year, I believe they're still working on discovery. There's some judgments that may be coming in. And so Joe Ray and I talked about a somewhat quick reset, subject to the court's approval.
All right, just one moment. Let me pull the file. All right, so the charges I have for your client, it's the possession 1 to 4, and then the possession 4 to 400. You say there is something else?
That's correct, Judge. There's a night mag case from January 1st, assault on a public servant.
All right, let me find your client on the docket. All right, so Mr. Garcia, on the new cases,
Yes, Judge.
and actually I have it listed as 2, Mr. Cobbs. So when are you expecting to have information on that to give to the defense?
Judge, I'm just reading the notes from intake. Just a regular reset and it should be enough to have the discovery and make an offer for all the cases.
All right, Miss Ferguson, could you put in the chat box a regular reset, please? All right, so Mr. Cobbs and Mr. Smith, we're going to come back on your case on March 17th. Mr. Cobbs, if you have the information before then, you can just let the court coordinator know and we'll bring it back sooner.
Thank you, Your Honor. May I get a breakout room with the third party representative of Mr. Smith?
All right, Mr. Smith, could you unmute yourself, please? All right, Mr. Smith. I'm going to send you to a breakout room with your attorney, Mr. Cobbs. After you finish conferring with Mr. Cobbs, you need to come back to the main room. Do you understand?
Yes, ma'am.
All right. Mr. Cobbs, I'm going to send you to breakout room number 2. And please make sure your client comes back to the main room. And let me just find you on the Zoom screen. All right. Thank you, Joe Ray. Ms. Efron, are you there?
Wait, Judge, I'm actually on the phone with Norma.
All right, just give me a moment.
Okay, so Your Honor.
Judge, can I see you in a breakout room with Lorraine?
Everyone,
Judge?
okay, everyone, just 1 second. Time out. Just give me a second.
Yeah, that would be great.
All right, just 1 second.
Okay.
All right, I had 2 attorneys come in. One was Tony Jimenez. Who is the other attorney who just came in, please? All right, then it's only Tony Jimenez.
Joseph Acevedo.
Okay. All right, Tony Jimenez, who do you have?
Kenneth Leach, Your Honor.
I'm sorry, who?
Kenneth Leach.
Criminal child division or family violence?
I think it's criminal trial.
What is it?
Marcus Sanders.
All right, that's criminal trial division. Just give her a couple more minutes. All right, I'm going to send you to breakout room number 10. I'm sorry, number 11.
Yes.
Tell me what motion it was, just so that I can have it ready for the test.
Joseph Acevedo, who do you have?
Criminal Trial Division, Anthony Whitley.
Oh, I saw that in girls today. Okay. Case number is 2021 CR 110.
Okay. I'm going to send you to number 12.
Thank you, Your Honor.
All right, and everyone, just give me a moment. I will be right back. Mr. White, do you need to speak with your client?
I did, Your Honor, and he accepts the offer. And I told the prosecutor that, but I have to give them my client's email to the prosecutor to
Yes.
Brittany. So should I just put that in the?
If you'll put that in the chat box, and then I'm going to move you to number 4. And I'm going to move your client to number 4 so you all can go over paperwork.
All right, thank you.
All right, and everyone just give me a moment. Ms. Efron, if you could come to breakout room number 1. All right, everyone, I am back. It's a Monday, but you know what? It's still a great Monday. So yeah. Let me see who is ready. So Norma, we are going to have to the clerks. Could you, Mr. Cobbs, are you done with Mr. Smith?
I am, Your Honor. I was going to ask that both he and I be excused. He did come back.
You're
from the breakout room.
excused. And to the clerks, could you call the jail and let them know that Smith 14I is excused?
Have a good Monday, Judge.
Thank you, you too.
Yes, Judge.
All right, any other attorneys ready beside Ms. Tchaikovsky? All right, so what is happening with your case?
Good morning again, Judge. I have conferred with Michael Villarreal, and he indicates that there is a new report with a JN number that just came in late last week. There's no CM assigned to it, so he'd like to email me those reports so we can discuss it to further confer about a resolution on this case and the possible new one.
All right, did he give you a ETA on when he expects to have that information?
He did not. I don't know if he's still on here, but he did say he would email it to me as soon as he had it.
And what is the new case?
I don't know, Judge. Possibly, I think he's mentioned a violation of protective order, a VOP.
All right, just one moment. Let me just see when he comes out of the breakout room. Let me request him to come in here so that we will get you a date.
Absolutely. Thank you,
He's
Judge.
back. All right, Michael Villarreal on Igor Olinsky.
Yes, ma'am.
Defense counsel is saying that he has 2 other cases. When will you have information on those cases for defense?
So one of them just came in, Judge, and Jane was not requested until the 4th. And so hopefully it's going to, I don't even know who the detective is on the case. And so hopefully within the next 24 hours, something will be uploaded so that I can, dig further from there. Because I don't even have an SAPD case number associated with it yet.
All right, so what are these misdemeanor cases or felony cases?
It's a new felony at large case.
And what is the charge?
Violation of a protective order by assault.
And is that the same complainant that's in this case?
I have no idea.
All right, we're going to bring this back within the week. Ms. Ferguson, on Igor Olinsky, can I have a setting date for next week, please? And this is for discovery. All right, we're going to come back on February 16th. And if there are any motions that need to be filed, both sides can file them, and then the court will set it for motions.
Yes, Your Honor.
All right, if there's nothing else, then we'll be back on February 16th at 9 a.m. And Mr. Olinsky, you'll need to appear in the 187 District Court in person on that day. Do you understand?
Yes, Your Honor.
All right, then, yes?
I will be in person in Guadalupe County that day. Is it okay that I appear through Zoom?
Yes.
Thank you.
You're welcome. All right, then you're excused. And Ms. Ferguson, can you note on the note on your file that Mr. Olinsky is to appear in person?
Yes, ma'am.
Thank you. All right, then you both are excused. Thank you.
Thank you, Judge. Have a great day.
Thank you, you too.
Bye-bye.
All right, any other attorneys ready?
I have some announcements, Judge.
All right, just one moment. All right, Mr. Navy.
On Domingo Martinez, Judge, we have an agreement. I've sent Norma the chat of my client's cause number and email. So we're going to be working on the paperwork to
Okay.
try to morning. And then Ernie Sanchez, Judge, he's in custody. I think he's on the Zoom right now.
Yes.
On this one, I've been in a lot of contact with my client, but mainly he's had some issues with bonds and warrants and things like that. His bond company got off of his bond. It wasn't due to some sort of violation or anything like that. I spoke with Miss Hayden, and she didn't have any objection to setting a $10,000 bond, which was his previous bond with the same bond conditions. I sent you and Norma an email with a proposed order. I think it was when you were out, when the court was out due to the freeze and everything like that, but I can resend that to you, Judge.
Let me see if I have that.
And Judge, sorry to interrupt. I just sent it to Lupe this morning with the agreement of the email.
Okay, so I'm just now having it now.
Okay.
Okay, and do you need to speak with your client?
Yes, Judge. And then also on Ashley Castillo, that's my last client. On this one, the allegation is a repeated violation of a protective order, and almost all of the evidence that I had to this point was just on one incident, but I've conferred with Ms. Hayden, and she sent over some additional information and evidence on the alleged other incident that makes up part of the continuous. And so I need to review that and discuss that with my client. If I could have a reset on that one.
All right, so on that one, you now have all the discovery?
I believe so, Judge. I haven't reviewed everything that I got this morning, but that was kind of what I was requesting, and she just sent a lot of it this morning.
All right, Ms. Ferguson, on Ashley Castillo, can I have a 30-day reset, please? All right, we're going to come back on March 15th.
Okay. Thank you, Judge.
Right.
May Castillo be excused?
Yes, Ms. Castillo, you're excused. All right, and then you need to speak with Mr. Sanchez.
Yes, please, Judge.
All right, Mr. Sanchez, I'm going to send you to a breakout room with your attorney. Mr. Navy, if you'll go back to breakout room number 3, and Mr. Sanchez, if you'll go to breakout room number 3, please. Andres Campion. Andres Campion.
Yes, good morning, Your Honor.
Good morning. Thank you for changing your name. And is someone here from Public Integrity?
Yes, Judge. Daryl Harris and myself are here.
All right, Andres Campion is having issues with his video.
Yeah, it's my video, Your Honor.
So I'm going to send you to breakout room number 8, and the prosecutors will meet you there.
All righty, thank you very much.
Sure. Ms. Calderola.
Yes, Your Honor. I need to speak with my client, and I don't see him among the prisoners in the courtroom. So,
Oh, no, he's here. I'm going to send you to number 9.
all right, thank you, Your Honor.
And Mr. Rivera, I'm going to send you to number 9. Hopefully that's the correct Rivera.
Judge, did I hear you say breakout room 8?
Yes, and you actually have the ability to go there.
Thank you, ma'am.
If not, I'll send you there.
Yes, ma'am.
All right, anyone else back from the breakout rooms? All right, I will finish signing documents. And to the clerks, I'm being told that there was an agreed order. Yes, yeah. And these files are done. Thank you. All right, and I know it appears that I am not doing anything, but I am actually working on paperwork and signing paperwork. And Marcus Sanders, Tony Jimenez is asking to speak with you again. Let me see if he's available. Yes, he's available. So I'm going to send Mr. Jimenez. I'm
Yeah.
going to send you to a breakout room. And it's number 13, and Marcus will meet you in 13.
Thank you, Judge.
You're welcome. Rebecca, I'm signing your paperwork.
Thank you, Judge.
You're welcome.
Your Honor, I'm back from the breakout room.
Okay, just give me one moment.
Yes, ma'am.
I'm just finishing up signing up some paperwork. All right, who's back from the breakout room?
Andres Campion, Your Honor.
And then Tony Jimenez, you're back. Do you need to be placed in the breakout room with your client again?
No, Your Honor.
Okay, all right then, just give me a moment. All right, Mr. Campion or Mr. Soto?
Yes, the state is going to be emailing us an offer, and I'm going to set up a time for Mr. Soto to come in and review that offer and review the discovery. And then we will be, I'm anticipating in generating a counter offer. But
Okay, let me see, the prosecutors are still in that room, so.
yes, they're conversing with each other.
All right, I'm requesting them to come out of the breakout room, so let's see what is happening. All right, everyone, what is going on with the case on Mr. Soto? You're on mute.
The state has extended an offer, and I think that Mr. Campion wanted some time to discuss it with his client.
Okay, so an offer has been tendered. An offer has been tendered.
Yes,
Yes,
Judge.
ma'am.
Yes, yes, Your Honor.
So we were brought here because there was some new video. So has the video been given?
There was a witness in the existing video that had never been interviewed, Judge. We interviewed her, and we are in the notes from that interview are tendered to defense along with the offer via email.
All right. So Ms. Ferguson, can we recall Mr. Soto in 2 weeks, please? If you could put a date in the chat box. All right, we're coming back on February 22nd. And then the next setting date I give you, Mr. Campion, will be a plea deadline date.
Okay, so the 22nd is not the plea deadline. Got it.
No. That is the date to make sure you've discussed everything with your client, which I know you will. And then after that, I'm going to give you a plea deadline date, Mr. Soto. What that means is when I give you that date, the court will not consider any plea bargain agreements after that date. Do you understand?
Yes, ma'am.
All right. All right, if there's nothing else, you both are excused.
Hey, Judge.
Thank you.
Judge.
Thank you, Your Honor.
And pleasant day, Your Honor.
All right, Mr. Harris, take care of that knee that was shattered.
Yes, ma'am. We are efforting.
Okay. All right. Mr. Jimenez, you have Mr. Leach.
Yes, Judge. The state tendered an offer. Mr. Leach has rejected it. The state is going to confirm the third-party witness statement, and we'll go from there.
All right, who is the prosecutor you were conferring with?
Marcus Sanders, Your Honor.
All right, Marcus Sanders.
Yes, Judge.
Yes, when will you have the information for the defense concerning another witness?
No, Judge, defense just asked me to verify that our witness is going to say the same thing that he said at the time of the offense. From my perspective, it won't change the offer, but I guess it may change how defense looks at the case.
All
Yes.
right. All right, so on this case, Norma, can we recall it back for February 22nd as well? Would that give you enough time, Mr. Sanders?
What was that date, Judge?
February 22nd.
Yes.
All right, so we're going to come back on February 22nd. Mr. Jimenez, for the
Yes, sir.
state to let you know that they've spoken to her.
Yes, Judge.
All right, if there's nothing else, do you need to speak with Mr. Leach anymore?
I do, Your Honor. Thank you.
Okay, Mr. Leach, I'm going to send you to a breakout room with your attorney and Mr. Jimenez. After you
Sure.
finish speaking with Mr. Leach, if you can make sure he comes back to the main room, please.
Yes, Judge.
All right, Mr. Leach, I'm going to send you to breakout room number 10.
Yes, ma'am.
Thank you. And everyone, just give me a moment. All right, Miss Christian.
Yes, ma'am.
Let's talk about your motion to withdraw. Is Mr. Rios?
He's in TDC and has been for over a year. So it's just that
I've
it's
already
just that
signed
the
them.
family keeps after me, and I just thought to be official, it would be best if I could just officially withdraw from those cases.
Oh, I've already signed those motions.
God bless you. Thank you so much.
All right. Yeah, I signed those time when they were given to me.
I appreciate that so much.
Yes.
On Mr. Van Duzer, Your Honor, And I don't see him on my screen, but we were conversing with him. We tried to talk him back into the general session, but I don't know where he is. He might be in breakout room 6. But anyway, Mr. Hitchings is on a drug case. I am on the arson case. The arson case, I'm going to have to give Mr. Joe Ray Garcia a thumb drive because the discovery would not load. And so I will be bringing that down tomorrow. So I guess we just need a regular reset if we could.
Okay, and I don't see your client on the Zoom. I think he may have mistakenly left the session entirely. Is your client on bond or is he on custody?
He is on bond, Judge, and he was actually in the general session this morning.
No, I see where he was here.
Okay.
But something happened. Is there any way you can call him so he'll know when his next court date is?
Yes, I got all of his contact information, and Mr. Hitchings has it also.
All right, Ms. Ferguson, on Mr. Daniel Van Duzer, can you give me a regular reset on this, please? All right, so we're going to come back on March 17th.
Okay.
All right, and both of you work with your client on working the Zoom. This may be him now. Let me see. Yes, it is.
Good. That makes me feel better.
Mr. Van Duzer, if you'll start your video, please. Thank you. Let me see where he is. Mr. Van Duzer. All right, Mr. Van Duzer, if you can unmute for me, please.
Hello?
Hello,
Can you hear me
Mr. Van Duzer. Your
Yes,
case
ma'am.
is going to be recalled for March 17th. It's so that your attorney can make sure that they have all the discovery. Do you understand?
Yes, ma'am.
All right, then you are excused.
All right, thank you, ma'am.
Thank you.
May we be excused, Judge?
Yes.
Thank you so much. Have a great day.
All right, you too. Bye-bye. Thank you, Mr. Hutchings. Have a good one.
Thank you, Judge.
All right, everyone, just give me a moment, please.
Judge?
Yes.
My client is considering the offer, but he was wondering, is there a bond on the MTR? You can't see that on the district clerk site.
What I will do, Ms. Calderola, I'll send you to breakout room number 1. And to the clerks, if you could go to number 1 and give that information to Ms. Calderola, please.
Thank you, Judge.
You're welcome. Tony Jimenez on Leach.
Yes, Judge. You asked us to come back. I spoke with Mr. Leach, and you've given us a date on February 22nd.
Yes, and let me see where your client is because I think he's still in the breakout room. Ms. Ferguson, can you let them know that L6 Leach can go back, please? All right. And Mr. Jimenez, if you don't have anyone else with us, you're excused.
Thank you, Judge. Take care.
Thank you. Bye-bye. Mr. Leach, we will see you back on the 22nd. All right, have a great rest of your day, Mr. Leach. And the person who's on the screen as Moto 5 in the white sweater, the female, what is your name, please?
Rose Michelle Lozano.
All right, Ms. Calderola.
Judge, there is no bond. Would it be possible to set a bond on the MTR?
All right, let me find your client. He's still in the breakout room. Let me have him come to the main session. Okay. And Ms. Ferguson, do you have an ETA on Mr. Buchier?
Let me check, Judge. Give me 1 second.
Thank you. And Mr. Sanders, I sent you an email on a dismissal that you sent me.
Yes, Judge, I'll look for it.
Thank you.
Judge, you want me to go to a breakout room or are we going to do a bond?
No, just give me a moment, please. I'm trying to get your client back to the main session.
Okay.
And with regards to the bond, have you spoken to prosecutor concerning the bond?
No, I'm going to speak with Mr. Groomer right now. Thank you.
All right, so Mr.
I'm here, ma'am.
All right, so Ms. Calderola, I'm gonna send you to number 6 and the prosecutor will meet you in that breakout room.
Okay, thank you, Judge.
You're welcome. And everyone, just give me a moment while I sign paperwork, please. All right, anyone ready?
Judge, I'm ready on Ernie Sanchez.
Yes. Yes.
Oh, sorry. This was the one where Ms. Hayden and I had agreed to a bond. And the reason the warrant went out in the first place was his bond company got off his bond. It wasn't due to an alleged violation or anything like that. And so we've agreed to a $10,000 bond, which was what it was set at previously, with the list of bond conditions that are in the motion or in the proposed order.
And Judge, if you don't mind, may I speak with you both in a breakout room just real quick?
Sure. If you all can go to breakout room number 2.
Okay.
And Mr. Navy, let me find you on the Zoom. All right, Ms. Calderado, just give me a moment. Let me go to the breakout room and then I'll come back for your case.
Yes, sure.
All right, we are back. All right, and let me find your client on the Zoom, just one moment. All right, where is Mr. Sanchez? All right, is this your client, Mr. Sanchez, Mr. Navy?
Let me check, Judge.
All right. If you can unmute yourself.
Hello, Judge.
Hi, Mr. Sanchez.
That's him, Judge. Yes.
All right, Mr. Sanchez. And Norma, can you put a month reset in the chat box for me? All right, so we're going to come back on March 17th. State on this case, is your offer still the same or has it changed or no? You're on mute.
I apologize. It's still the same, Your Honor.
All right, so that's going to be your regular reset date, Mr. Navy, from yourself and Ms. Hayden and I being in the breakout room. The court is aware of the difficulties you've had contacting your client through no fault of your own or his own. So March 17th is going to be a regular reset for you to go over the offer with your client, review whatever you need to review. It's Ernie Sanchez. It's 2000, I have something in the chat box. It's 2021 CR 10230, Ms. Ferguson. So that'll give you a chance to review whatever discovery and go over the offer with your client. When we come back on March 17th, that's the date I will give you a plea deadline date. All right, Mr. Sanchez, the defense and the state have agreed to reinstate your bond or set your bond at its previous setting because they've realized that there was an issue, communication issue with your bondsman. Court is understanding of that. However, what you need to understand is your charge is violation of a protective order or repeated violation of a court order or bond orders. Here's the thing about that, Mr. Sanchez. I don't take any of this as true because I haven't been presented with any evidence on anything. Do you understand? But what I do know is there is somebody that you're not supposed to be having contact with. And when I say no contact with them, that means since you've been in the jail, you better not have been calling them. That means no email, no text, no, oh, I happen to see them at the grocery store. Let me go say hi to them. No going by their homes, no Instagram, no LinkedIn or whatever. How old are you?
I'm 33 years old, ma'am.
All right. I would say young people, but to me, when you're in your 30s, you're no longer, considered super young. I mean, it's still 20 odd years younger than me, but
We're still young.
you're not so young that you don't know better. So
Yes, ma'am.
you are not to have any contact with the complainant in this case. Do you understand?
Yes, ma'am. Loud and clear.
So it is as if you do not know this person at all. Do you understand?
Yes, ma'am.
Let me just explain what's going to happen. If you have contact with this person, you know what's going to happen. I'm going to get an order that's going to be a violation report. And in that violation report, that's what it's going to say. You're going to end up being remanded without bond, and we're going to end up having a hearing on this. And then the state will present whatever evidence they have and whatever witnesses they have, and your attorney will present to me whatever information he wants to present. And then I'll make a decision on whether or not to continue your remand without bond. Do you understand? Or either bond increase?
Yes, ma'am.
I've been a prosecutor and I've been a defense attorney. And sometimes my clients would make it more difficult for me than need be. So you know who the complainant is in this case, right?
Yes, ma'am.
And you know you're not to have contact with them at all. Do you understand?
Absolutely, ma'am.
And I don't know if this is a female. I don't know if you all have children together. I don't know any of that. But I will tell you this. If you all have children together, you better not be contacting her and sending messages through. And when I say no contact, that means sending messages through third parties. Because sometimes people are like, well, I didn't contact her, but I told my brother or my mother to tell her A, B, and C. No.
Not at all.
And I know Valentine's Day is coming up. Guess what? Don't send any cards, no flowers, no teddy bears, none of that. Do you understand?
I very much understand. My fiance would wring my neck.
Okay. So does everybody understand? I think I've made it as clear as I can possibly make it that there is to be no contact.
Yes, ma'am.
All right. Then we'll see you back on March 17th. If you're out of custody, then you'll need to appear by Zoom.
Okay, sounds good, ma'am. Thank
All
you,
right.
ma'am.
Thank you.
Thank you, Judge.
You're welcome. Yes. Norma 14J can go back. Lorraine Efron. Let me move her to the main room. Her client, let me add him to the spotlight. Mr. Boutier. Good morning. Happy Monday.
Good morning.
How are you doing today?
I'm up and down, but I'm still blessed to be here.
Oh, that is awesome. So this is what's going to happen. Ms. Efron, if you could show your video for me, please. Just one moment. Let me get her here.
I'm here, Your Honor.
No, it's just that everyone's jumping around on the screen on my end because I see everything. So people don't realize how difficult it is until you host and you have like 80 screens and everybody is moving because when people move out. All right, Mr. Boutier, I'm going to mute you just for a little bit.
Yes, ma'am.
Because there's noise coming from your end and I want you to be able to hear what I'm saying and I want your defense attorney to be able to hear what I'm saying. Oh, noise has settled down. All right, Mr. Boutier, here's the thing. You're on this docket and you have charges against you. I don't take any of these charges as true because nobody's presented any evidence to me. Do you understand?
Yes.
But this is what I do know. I do know that the state, I make sure that the state has given your attorney all the discovery. I make sure that they tender her offer. So here's the thing. Ms. Efron is your attorney. And you can speak to her or not speak to her. I always tell people, if you don't want to speak to your attorney, that's fine. But if you want to end up going to trial without having speaking to your attorney, that's all on you. There's not going to be a situation where I have a case before me and it's 8 settings, and then the jury comes up and somebody tells me, wait a minute, I've never spoken to my attorney. I want to speak to my attorney. I'm not going to do that. So your attorney is here. You're here. I'm going to send you both to a breakout room to communicate with each other. Now, in the 187 District Court, this is what I require. I require everyone, treat everyone with respect. I don't care what your occupation is in life. I don't care what you're charged with. We should all treat each other with respect. Some people will say, that person's a doctor or that person's a judge, so they should be treated this way. And no. And the reason why I say that is because in order for our society to work, we need people of all professions. Guess what? We need somebody to do somebody's lawn. We need somebody to, be a cashier at the grocery store. Although, hint, hint, I think they're trying to do away with cashiers with the self-serve. That's the way they started at gas stations. They no longer have full service. So I say that to say this, Mr. Gutierrez. Ms. Efron is going to treat you with respect, and I ask that you treat her with respect as well, okay?
So it shall be. Yes, ma'am.
All right, so let's make this a happy Monday. Mondays can be as happy as we make it, all right? So I'm going to send you to a breakout room with her. But your next court date for this court is going to be February 24th, okay? You have other court dates with Judge Carruthers, but for here, it's February 24th. So I'm going to send you to a breakout room with Ms. Efron. I'm going to send you to breakout room number 2. Ms. Efron, when you finish speaking to him, you could have him come back to the main room, please.
Yes, Your Honor. May I be excused from there, or would you like me to come back as well?
Once you make sure he comes back to the main room, then you can be excused.
Okay, thank you, Judge.
Thank you. All right, Ms. Calderala.
Yes, Your Honor.
All right, Ms. Ferguson, you have someone help Mr. Boutier go to the breakout room number 2, please. All right, Rivera, have you discussed the bond issues with the state?
I have, and he's recommending a $35,000 bond on the MTR.
Okay, let me see if I can find your client. And the prosecutor was Mr. Groomer?
It was, Judge.
All right. Okay. All right, so have you talked to them about the actual contents of the motion to revoke?
Yes, Your Honor, and we've conferred and we have an offer.
So what, is this going to be a contested?
No, Your Honor, my client just wanted to know if he could get a bond on the MTR. And I think if we set a bond, I think he'll reconsider the offer. At least that's what he told me.
All right, can I see both parties in a breakout room, please? If I can see you both in breakout room number 1. And everyone, just give me a moment, please.
Yes. 17.
Okay, let me see. All right, Joseph Acevedo on Whitley.
Morning, Your Honor.
Morning.
We've conferred, still working on some additional discovery.
Who's the prosecutor you were conferring with?
Joe Ray.
Yes, Judge.
All right. So what discovery are we missing?
Judge, looking over, I think the only thing missing is dash cam, which can be done quickly.
I'm sorry, is what?
Coban, dash cam.
All right. So how much time do you need for that, Mr. Garcia?
Just a regular reset or 2 weeks, whichever is fine.
All right, Ms. Ferguson, can you recall this back for 2 weeks, please? And Nathaniel Navy, I'll send you to breakout room number 5. And you need Mr. Domingo Martinez.
Yes.
You go to number 5, please. All right, so we're going to come back, Mr. Acevedo, on February 22nd, and that will be for discovery.
Thank you, Your Honor.
Thank you. You and your client are excused.
Thank you.
All right.
Judge,
Oh,
this
I'll
is
help
Mike
you with
White.
that.
Judge, may I speak?
Just 1 second.
Okay.
All right, Kelly Piddle.
Yes, Your Honor, my client hasn't
No,
got.
no, I said Kelly Piddle.
Oh, I'm sorry.
Oh, that's okay,
Judge.
Mr. White. I have people in order. So when you're on spotlight, that means you're in order.
All right.
Hi, Judge. Just checking to see if my client had joined the Zoom, Christopher Rodriguez. I don't see him, but.
All right, is that prosecutor available?
Joe Ray, Judge.
All right. Court is calling. I'm sorry, Brenna. Court is calling 2021 CR 7773, State of Texas versus Christopher Rodriguez. Can I have parties announced for the record for the state?
Joe Ray Garcia.
For the defense?
Kelly Piddle.
All right, this hearing was set at 9 a.m. It is now 10:33 a.m. Deputy Laura, has there been a Christopher Atlee Rodriguez in the courtroom at all today?
No, Your Honor, he has not.
And for the record, there has not been a Christopher Rodriguez on the Zoom screen as well. And I would like the record to reflect that all parties on the Zoom screen have a name attached to their screen, and there has not been a Christopher Rodriguez on the Zoom. Defense, have you had any contact with your client?
I have for every other setting except for today, Judge. And this is just to make the court aware, this is our 4th reset for discovery for the state missing discovery, and the state is not ready for trial. So just to throw it out there.
Okay. Is the state not ready for trial, or has trial been suspended?
State's not
Have
ready for
jurors been
trial.
suspended?
They're missing discovery. They have for 4 settings now.
All right, we're going to recall this then. State, any objection to recalling this for tomorrow to see if Mr. Rodriguez is going to appear?
None from the state.
All right, I'm going to note on the file that the defendant was not present today at 10:34 a.m. This is going to be recalled for tomorrow. Mr. Piddle, and your client needs to appear.
Thank you, Judge. And I apologize for my attire. I'm in the hospital. So
Oh, I didn't know you were in the hospital. How are you doing? What's going on?
my wife had a baby. So we're waiting to be discharged. So
All right, so she had a baby, and you looking all fresh as a daisy.
You like to see the little couch I slept on. I wouldn't say it's fresh as a daisy.
Well, congratulations on the new baby.
Thank you, Judge.
Now there is somebody who's going to be running the household.
Yes.
It won't
yes,
be you, it's the baby.
That's exactly right.
All right, well, have a good one. Congratulations.
All right. Thank you, Judge. See you tomorrow.
You're welcome. Let me find Mr. Rodriguez on the docketing sheet. There we are. All right, Mr. White, Michael White.
Yes, Your Honor.
Yes, what is happening with your client?
Well, he hasn't been given the forms for a right of appeal and for consent to the video conference in place of in-person hearing. So I don't.
All right,
I
if
don't
y'all would go to breakout room number 4 and discuss that, please.
Judge, give me just a second. I went into the breakout room. I asked him for the email. It's been sent. It's in his defendant's email address.
All right, go to number 4.
Go to number 4. Okay.
All right, you're ready on Kevin Bills, Mr. Davidson.
Yes, Your Honor.
All right, to the courtroom. Is Mr. Bills in the courtroom?
Yes, supposed to be.
Okay. Who's the prosecutor on Bills?
Your Honor, I am, and we just, before we start, I just make the court aware that we have the victim here and she was wishing to testify that she didn't speak to the PSI officer.
Just a little bit back because it's.
All right, Mr. Davidson, are you prepared to, for sentencing, knowing that the state is bringing in a witness?
Yes, Your Honor. I'm sorry, Your Honor, Matt. I just have to, I'm sorry, I have to get this dog out of this room real fast. I'm sorry he came in here. I apologize.
Oh, no problem.
1 second, I'm sorry.
Sure.
Thank you for your understanding, Your Honor.
Oh, sure. We are going to go on the record. Court is calling 2021 CR 4055, State of Texas versus Kevin Roy Bills. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
William Davidson.
And are you Mr. Bills?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
None, Your Honor.
Any objection from the defense?
No, Your Honor.
All right, the court will note for the record that on December 14th, the defendant entered his plea to count 1. He entered a plea of no contest and he entered a plea by video. And the court will note for the record that the defendant is present in the courtroom. According to the plea bargaining agreement, the state proceeding on count 1, punishment was to be assessed at a cap of 10 years in the prison. The state is silent on the defendant's applications. And this is to run concurrent with county court case. And also there's to be no contact with Rose Lozano. Have both parties had a chance to review the PSI report?
The state has.
Yes, Your Honor, the defense has.
Any objection to the PSI report from the state?
None, Your Honor.
Any objection to the PSI report from the defense?
No, Your Honor.
All right, then the state is silent on your application. Defense?
Yes, Your Honor. My client is a 46-year-old. He works, he has a good job. He works at B&G Staffing. And what that is a make ready. They make ready for houses. He's been having a stable job there for over a year. He also works in automotive repair, and his goal is to own his own automotive repair shop. He's been in a relationship with a woman who's in the courtroom right now since 2012. It's been kind of on and again, off again. And most of his cases, his prior cases were all drug related. Most of them were dismissed. He has not been in trouble since 2012, which is a long time. And so he's really turned his life around. And this was a odd event that occurred out of nowhere. There are some mitigating circumstances, but my client is really asking for probation. He identifies himself as a Baptist. He says that he plays church drums and that he really has a passion for his drums. And he also has several children. On the TAP evaluation, he's told me that if you give him probation, he will do whatever you tell him to do with respect to any kind of classes, whatever they are. And beyond that, Your Honor, I'm just asking the court to give my client a chance at probation, because if he doesn't make it, if something happens, the court can revoke him. He's already been waiting for this hearing for 2 years, and nothing's happened since then. He's been reporting in. He's had me ask the court a couple of times to monitor the GPS, to change the GPS so that he can go to work, and he's continued to work. And that's his story, Your Honor.
All right, Mr. Davidson, do you want to address the issue as to why he would try to set fire to a complex?
Your Honor, from what I understand, I don't understand the details regarding the fire, but I do understand that what my client tells me is that this other lady, Michelle Lozano, that he was with at the time, had taken his property and pawned it at a pawn shop. And apparently there's police reports to substantiate that, and he had to go get it. And I think that certain things can just set people off, and I don't have any excuse for that. I'm just trying to get some mitigating factors in, Your Honor.
All right. Would you like to call your client as a witness or no?
My client has not said that he wants to address the court in any way.
All right, State.
Your Honor, State would just call for purposes of the court edification of the victim's impact. So the State would call Michelle Lozano.
All right, so the State is silent. So what is the State calling her for?
Your Honor, the victim was contacted by the PSI officer as reflected in the PSI report, but she was unable to contact with him to make successful contact. And so we are just asking that the court be aware of what she would have told the PSI officer, essentially.
Defense?
Your Honor, I object to that because she had been contacted previously and had told the PSI officer she wanted to make a statement, but then they tried to get a hold of her again and again and again, and they couldn't do it. I was just informed this morning that she had shown up on Friday at the DA's office and wanted to make a statement. I don't have any objections to a victim impact statement, but this is a direct effect on the actual sentencing, and I think it's inappropriate.
All right, so here are the issues, and Ms. Lozano, I want you to understand the legal issues. These are the legal issues. The State made a plea bargain agreement with the defense. And in that plea bargain agreement, the State was to remain silent on the defendant's application for deferred adjudication. The only thing that the State is allowed legally to present evidence on is if there are some fact issue. And when I say fact issue, I mean if there's a denial or if there's a dispute over evidence that has been presented by the defense counsel. And in this case, if the State is not saying that there's been some dispute over what the defense counsel has said, then according to the plea bargain agreement, the State has no evidence to present. Do you understand, Ms. Lozano? Can you unmute, please?
I really don't understand. I've been cooperative.
All right, so let me try to explain it in layman's terms. The state and the defense have a plea bargain agreement. Do you understand that?
Yes,
Okay, so as a part of the plea bargain agreement that the state reached with the defense is that the state was not going to present any evidence or any testimony saying that they don't want Mr. Vales to have deferred adjudication. So do you understand that?
no, not really. I don't know what any of that means.
Okay, well, let me break it down a little bit. Mr. Vale has applied for deferred adjudication. That's a form of probation. Do you understand? I'm sorry? All right. The state, according to the plea bargain agreement, they are not going to say that they want Mr. Vales to have deferred adjudication. Do you understand?
That they don't want him to have probation.
No, no, no. Two things the court can do today. The court can either give Mr. Vales deferred adjudication, which is a form of probation. Do you understand that? Or the court cannot give him probation. Do you understand that?
Yes,
In determining whether or not I should give him probation, the state is not going to present any evidence to me with regards to that. Do you understand?
yes, ma'am.
And the reason why they're not going to present any evidence to me is because a part of their plea bargain agreement is the state would not do that. Do you understand?
Yes, ma'am.
Now, if the defense attorney or Mr. Vales were to say something that wasn't true, then the state could correct that if they think it was untrue. Do you understand?
Yes, ma'am.
So that's the only time the state can present evidence to me. Do you understand?
Yeah, so I'm not, I mean, I'm still,
But no, I just want to take you step through steps because sometimes people don't understand the legal process, okay?
okay,
So have you understood what I've said so far?
ma'am.
All right. So unless there is something that there's a disagreement over facts that the defense attorney has presented to me, then the state is not allowed to present anything. Do you understand?
Yeah.
And that's because of the agreement that was reached between the defense and the state. Do you understand?
Yes, ma'am.
So the defense now has stated that they don't want you to testify because there was a plea bargain agreement that was reached with the state. Do you understand?
Yes,
And part of that plea bargain agreement was the state was not going to say that they wanted Mr. Vales to have probation or not have probation. Do you understand?
ma'am.
All right. So that is why I'm sustaining the defense's objection, which means that you're not allowed to testify unless there is something presented to me that is a fact issue dispute that has been brought up by the defense counsel. Okay.
In Your Honor, the language of our agreement states that the state reserves the right to speak as to factual issues. A factual issue in this case would be the impact that this is sustained on the victim. And so it's not in front of you. This would typically be considered in a PSI, and just the fact that it's a documented communication with a PSI officer versus a live testimony, I don't think really is different. If she were to have spoken to the PSI officer, the court could consider that information. And so we're just asking that she testify just to that limited circumstance. The state is not going to make any argument or refer to any refer at all to the defendant's application for deferred adjudication. And so that's the state's position.
Well, here's the court's position. This is a contract. It's a parole evidence rule applies, as everyone knows. So the court does not go outside the four corners of this. Ms. Lozano, whenever you have a contract with somebody, This is the contract that the state and the defense reached. So what I consider is this page. That's the contract that has been reached by the state and the defense. And if parties were not ready to proceed, then parties should have said, we're not ready to proceed. We need a continuance. We want to do an addendum to the PSI report, but nobody said that. So we're going forward with this hearing. And so the court's ruling stands. If there is an issue of fact, then yes, the state is allowed to speak on that. But there hasn't been an issue of fact that has been brought before the court because this is the plea bargain agreement. The defense has made their statements asking for their client to receive deferred adjudication. And the state has not presented the court with any evidence that what the defense counsel has said has been untrue or is leaving the court with a false impression. So therefore, legally, it's not allowed, Ms. Lozano, because the plea bargain with the state is this. And according to this, the state, and I'm going to read you what it says. It says, it is mutually agreed and recommended by the parties. Prosecution should proceed only on count 1, which is arson, habitation, place of assembly. Punishment is to be assessed at a cap of 10 years. There's a $1,500 fine. State will make no recommendation of defendant's deferred adjudication or community supervision application. State reserves the right to speak as to factual issues relevant to the defendant's punishment. This is to be concurrent with County Court Cause number 650388. There's to be no contact with Rose Michelle Lozano. So, I mean, the state is to remain silent. So that's where we are. Mr. Villarreal, would you like to speak with Ms. Lozano in a breakout room?
I have previously spoken, Your Honor, and at this point, the state would ask for a continuance in order for her to be able to speak to the PSI officer.
All right.
Your Honor,
yes.
May I address that?
Yes, you may.
I object to that because the only thing that she could talk to the PSI officer about would be the victim impact statement, because the state is silent on whether or not he's going to get probation. Anything coming from this witness is going to annul basically that agreement, other than a victim impact statement. And both parties have already said they're ready to proceed.
All right, just give me one moment. I'm signing a document, just 1 second. All right, so where we are now is it is February 7th. This plea was entered into on December 14th. The court has reviewed the PSI report. And in the PSI report, this is what I have under victim impact statement. Number 5, the victim indicated she would submit a victim impact statement prior to sentencing. Number 6, the victim indicated she would submit a victim impact statement prior to sentencing. Number 7, she'd like to be notified of future hearings. Number 8, on December 16th, the officer spoke with the victim. Ms. Lozano was informed of the plea bargain and the defendant's PSI court date. She's seeking monetary compensation and would provide the information ASAP. Concerning the defendant's application for probation, Ms. Lozano stated she would submit a victim impact statement prior to sentencing. Upon receipt of any information, it would be forwarded to the honorable court. February 3rd, this officer attempted to contact the victim as a follow-up. A message was left for a return call. To this date, there has been no response. Upon receipt of any information, it will be forwarded to the court. So this case has been set since December 14th. So we had the entire month of January, and now we're at February 7th. So defense's objection is sustained. All right, any further argument from either side?
State
And the
silent.
state, yes, the state is silent. Anything else from you, Mr. Davidson?
I'm just asking the court to please give my client a chance to continue his life. He's been doing very well the last 2 years, and he's reported on the GPS every single time. He's got a good job, and I would just ask that the court consider the possibility of allowing him to be on deferred.
All right. As a part of entering his plea into this case, Mr. Bills waived the right to remain silent as a part of his plea.
I'm sorry?
As a part of his plea in this case, he actually waives the right to remain silent as it relates to this case.
Okay.
So it says, a part of the wavering consent to stipulation of testimony and stipulations document, which was accepted into evidence without objection. It states, in particular, counsel has explained and the defendant understands the privilege against self-incrimination and the confrontation and cross-examination of witnesses. Understanding all these rights, the defendant knowingly and voluntarily agrees to waive each such right and consents to waive appearance, confrontation, and cross-examination of witnesses against defendant, including all statements and information contained within the pre-sentence investigation report. So he's waived his right to remain silent as it relates to this case. So Mr. Bales, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, Mr. Bills, what is your relationship with the complainant, Ms. Lozano?
None.
All right, so why did you commit this offense?
Excuse me, Judge, could you go back? You said, what is my relationship to her now?
Now, why did you commit this offense?
Stupidity.
Now, I mean, what were you thinking when you had to take gasoline out? I want to know your thought process because I'm trying to make a decision on whether or not.
And that's what I'm saying, Judge. Upset, angry, was not thinking.
Well, no, there's a thought process that goes along with this because you have to get gasoline. So you got gasoline. What were you thinking when you got the gasoline?
Actually, I had it for my car at first.
Okay.
It was already.
Walk me through.
All right. The gas been in my truck, in my car for a minute because I had to go put gas in the car. So I had 2 vehicles at the time. So, and it's basically like when the officers brought me over there to get the rest of my belongings, they wouldn't give it to me. And I worked my behind off to get my belongings. And basically when I had someone to call and ask, could you just please give me my belongings? She ejected the phone from the guy and said, you'll never see your shit again. Basically like that. So out of anger, didn't think, whatever, mind went blank, you know what I'm saying? And that's why I said when you first asked me, stupidity, not thinking. Learned from it, moved on, found out later that it was pawned. And like I said before, you know what I'm saying, it's just that I thank God that no one was hurt, because that's not even my MO. I wasn't raised that way, you know. And it's just like it never happened again.
All right, so what was pawned?
My stereo. The $3,000 stereo.
Well, I mean, at that time, I'm sure it's not worth 3,000 because as we know, everything depreciates. And what else was pawned besides that?
That's all I was really trying to get.
No, you're saying that things were pawned. I'm trying to figure out what things.
That's the only thing, is 3 pieces. That's the only thing was pawned. That's what I was trying to get, man.
Okay. All right. Do you have any children?
Yes.
What are their ages?
9, 20, 25, 17, 16.
All right. And where is the 9-year-old and 16-year-old?
Dallas and Decatur, Georgia.
Okay.
He graduated this year.
All right. Do you have any children with Miss Lozano?
No.
Have you had any contact with Miss Lozano since this case?
No.
All right, off the record for a moment. Ms. Calderoa, Ms. Ferguson is asking that you go to breakout room number 2, please. All right, we're back on the record. If you're drug tested today, what are the results going to be? And know that you are going to get drug tested today.
I really don't know. I ate a weed edible.
I'm sorry, what?
A weed edible.
You ate a weed edible?
Yes.
When's the last time you used drugs?
That was a while ago.
What is a while ago?
Months, years.
Well, I mean, it's not months or years. If you're saying you ate a weed edible.
I ate a weed edible like a couple of days ago.
Okay, so that's use.
Yes.
All right, anything from the defense? You're on mute, Mr. Davidson.
I can just reiterate that any kind of drug treatment, any kind of classes, anything the court could recommend, he's willing to do it. He has told me he doesn't believe he has a drug problem, but if the court believes he does, and if the court gives him deferred, he's certainly going to obey whatever the court says.
All right, anything from the state?
Your Honor, now that the court has brought up a factual issue about contact post this incident, we've asked to call the victim to talk about contact since the incident offense.
All right, Ms. Lozano, if you can unmute and raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? We cannot hear you, Ms. Lozano.
Yes, ma'am.
All right, what I'm going to need you to do is I'm going to need you to make sure that you're close to your audio so that the court reporter can hear.
Yes, ma'am.
All right, will you state your name for the record, please?
Rose Michelle Lozano.
All right, state.
All right, Ms. Lozano, you heard the defendant testify that he had no contact with you since the arson case. Is that true?
That is not true.
How has he attempted to contact you or has contacted you?
He has attempted to contact me in various ways, through social media, through text messaging, through messenger, through friend requests, through third parties, coming to my home to tell me things that he has stated.
Okay, and when he has had contact with you, what is the general context or what's the general, what does he tell you in general when he's contacting you?
I was told by SAPD to
Your
only.
Honor, object on the basis of hearsay.
Sustained.
And Ms. Lozano, I'm just asking what Mr. Veals has communicated to you. What has he communicated to you?
Your Honor, that's the same objection. It's just the.
Just one moment. All right, if it's something that what Mr. Vales has said to you personally, Ms. Lozano, you can answer the question. But if it's something that the police have told you or somebody else has told you, that will be sustained.
It is through text messaging, through several text messages, through Messenger, through phrase requests, just mentioning that he is not going to go anywhere, that he believes that me and my children are his family, that he will not leave us alone until I decide to marry him, to be with him. This is not over. Just the same things of that nature. He has sent me pictures of various wedding rings, telling me to please marry him, to please forgive him, that this can all go away. There has been attempts for me to meet him for money. Just meet him and he'll give me money. He'll give me whatever I want as long as I'm with him.
Okay, thank you, Your Honor. At this time, the state would pass the witness.
All right, defense.
Ms. Lozano, do you know any of those specific occasions, the dates or anything specific?
There's been over 20 police reports that have been made. I don't have all the police reports in front of me, but SAPD does have screenshots of every single report that was made, as I was told that each text or message request or friend request was a violation regarding my protective order and emergency contact order.
I have no further questions for this witness, Your Honor.
All right, any redirect state?
Nothing further, Your Honor.
Okay.
Your Honor, may I ask my client a question regarding that?
Yes, if you would like to call Mr. Veals.
Mr. Veals, you did tell the court that you didn't have any contact with her since this last incident. Is that true or not true?
I haven't reached out to her. I have got text messages from her, but I haven't reached out to her. And for as Facebook, my Facebook been hacked 3 times. I haven't reached out to nobody because basically I've been going to work and my fiance is in the courtroom. So I don't know what they're talking about. And I ain't sent nobody no wedding ring because I wasn't trying to get married. And
So
that's one of the text messages. That was one of the text messages that they sent me. That I want to be more than friends, and I want us to get married. And I know you buy that beat Kool-Aid. You know what I'm saying? So I haven't texted anybody. It was even asked to why I wasn't responding. You know, so I don't know what's going on.
All right, so is there anyone aware of any of these text messages that the defendant is stating that the complainant has sent him? I mean, is this true? Is this not true?
Oh, you asking me?
State defense, does anyone know of any text messages? Because so far, the testimony that the court has heard is that the defendant is sending the complainant text messages. Now I'm hearing that the complainant is actually sending the defendant's text messages. Excuse me, don't interrupt.
Sorry.
I'm trying to figure out what is the truth here.
Your Honor, I can say that I reviewed the evidence and the discovery that the ADA has sent me, and I do not recall any text messages or evidence that is now being presented.
All right, I'm going to send you and the state to a breakout room and see if you all have the answers to the court's questions. And this is what I would like to know. I would like to know whether or not, and Mr. Villarreal, the court is in receipt in the plea agreement of text messages from this defendant to the complainant. So the court has that as a part of the stipulations, but I would like to know whether or not the complainant has actually been texting the defendant or not. So what I'm going to do is I'm going to send you all to breakout room number 1. And Ms. Winter, I'll send you to breakout room number 1 with your with the prosecutor as well. And then if you all would like to have the complainant in breakout room number 1, just let me know.
Okay, thank you.
All right, Mr. Ville, you can have a seat. All right, we're going to take up the matter of Jarma Perez, and then after Jarma Perez, we're going to take up Martinez Domingo.
Judge, will you give me just 1 second?
Yes. Who's the prosecutor on Perez?
Brittany, Judge.
That's
Who?
Brittany.
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 All right, thank you. And Rebecca, on this one, there's an application for community supervision as well as on Domingo Martinez.
Thank you, Judge.
Paul Smith, who are you here for? You're on
I am
mute.
here for Mr. Tyke, Thomas Tyke.
Criminal trial division or family violence?
I think it's family violence, actually.
All right, I'm going to send you to breakout room number 3.
Thank you.
And I'm ready, Judge, whenever.
All right, thank you. Court is calling 2021 CR 1076, State of Texas versus Jarma Perez. Can I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
Michael White for defense, Your Honor.
And are you Jarma Perez?
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Perez, I'm showing you a document entitled Defendants Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Court, I'm sorry, Mr. White, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Perez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Perez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review this document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with is driving while intoxicated, 3rd or more? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir. Yes, ma'am.
Mr. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 3 years in the prison. There's a $1,000 fine. The state recommends community supervision, and there's no application for deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did
Yes,
you
ma'am.
electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a top evaluation, 120 hours of community service restitution, the ignition interlock for the full term, DWI intervention, VIP live. And state, are you requesting for a driver's license suspension as well?
Judge, forgive me, but is that required on a DWI third? Okay, I apologize. Yes.
Okay. That's okay. I mean, it happens. All right, did you understand those are recommendations from the state and the court does not have to follow those recommendations, Mr. Pettis?
I did. Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
State offer states Exhibit 1 and all attachments.
Any objections?
No objection.
Mr. Pettis, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing? Mr. White,
Yes, ma'am.
Yes, I'm sorry.
are we proceeding with sentencing?
Yeah, there should be sentencing, yes.
No, are we proceeding with sentencing?
Yes, yeah.
All right, Mr. Pettis, are you employed?
Yes, ma'am.
What do you do?
I am a supervisor of construction company.
All right, when's the last time you had a drink?
Over a year ago, January 11th, I believe.
Well, usually
Be-
people who
be
are in their
exact.
sobriety, they know exactly.
It's January 11th.
All right. So how are you maintaining your sobriety? Do you have a sponsor? What are you doing?
I am in cognitive behavioral therapy. I was not drinking prior as well, and I gave myself a relapse for my 50th birthday. So I've been in the program quite a while as well. With the pandemic, I have not been attending meetings, but I am in therapy.
Okay, so who are you receiving the therapy from?
It's Miss Martinez through, what is it, Psychosomatic Institute, San Antonio.
Do you have any children?
I do not.
All right, this is what the court is going to do. The court is going to sentence you to a $1,000 fine that'll be probated, 3 years in prison, suspended and probated for 3 years, 120 hours of community service restitution. 40 of those hours will be waived if you provide proof that you've completed the entire regimen of the COVID vaccination. Court is not requiring anyone to take the COVID vaccination, but if you do, you'll receive credit for that. There's to be ignition interlock for the full term of your probation, DWI intervention, VIP live, 2-year Texas driver's, 2-year driver's license suspension, proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. You're to continue with the cognitive behavior therapy through the Psychosomatic Institute of San Antonio. You're to sign a release so that probation can make sure that you're doing that. I'm going to want outpatient treatment as well with probation. There's to be regular reporting by Zoom. There's to be random field visits, 1 time per month. Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Pettis, is there anything else that you need from the court in order to be successful?
No, ma'am. I do have a question concerning my Scram device.
That will remain.
Okay.
And if if you're driving, you do need the ignition interlock. So either you can drive or and have ignition interlock full term. If you're on Scram, Rebecca, if he's on Scram, then he needs to provide an affidavit that he doesn't have any vehicles at his home or access to any vehicles. Otherwise, I'm going to want ignition interlock, and that's going to be for the full term. If he's on Scram and not ignition interlock, then Scram will be for the full term. So you will be on the monitoring device for the full term of your probation. Do you understand?
Yes, ma'am.
One or the other. Showing you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, we can go off the record. Mr. Pettis, you were out celebrating your birthday, and in being out celebrating your birthday, you could have killed somebody. I haven't done any statistics on this, and my statistical professor will be very upset with me for saying this because I haven't run the numbers. But usually what ends up happening is people who drink and drive, they don't think they're going to kill anybody. But you know what ends up happening? They end up getting in an accident. Somebody's taking their child to a recital or something, or there's some grandfather who's out just trying to enjoy his day, and he gets hit by a drunk driver. And usually the drunk driver is just fine. Once they sober up, they're crying because they realize they killed or injured somebody. So obviously for you, you can't drink alcohol at all.
No, I can't.
So you need to remember not to drink alcohol at all, okay?
Yes, ma'am.
I'm going to send you to breakout room number 1. Please wait there patiently. Probation will be there with you shortly.
Okay, thank you.
All right, Nathaniel Navy.
Yes, Judge, I'm here.
All right, we're going to take up your case. And I just sent you paperwork. And it's for Rivera. Who's the prosecutor on Domingo Martinez? It's family violence.
I am, Your Honor.
All right, thank you.
Thank you.
Your Honor, am I excused, Michael White?
You need to go to the breakout room with your client.
Oh, okay.
Thank you. Court is calling 2021 CR 9452, State of Texas versus Domingo Martinez. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Nathaniel Navy, Your Honor.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Domingo, I'm showing you what's entitled Defendants Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, Mr. Martinez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault family second? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to enter into a plea bargain agreement and give up those rights in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney, and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, your punishment is to be assessed at 4 years in the prison. There's a $1,000 fine. There's no application for deferred adjudication. The state recommends community supervision. There's an affirmative finding of family violence, and there's to be $100 to a family violence, an approved family violence center. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Judge.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 80 hours of community service restitution, the BIPP course, and no harmful or injurious contact with Carla, K-A-R-L-A, Garza. Did you understand that those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence to support the defendant's guilty plea?
Yes, Your Honor. State would offer State's Exhibit number 1 and its attachments.
Any objections?
No, Your Honor.
Mr. Martinez, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We're fine with waiving PSI.
All right, anything you want to say on behalf of your client?
Judge, just that he accepts full responsibility for this. He's never made any excuses for it. He understands that he made a terrible decision. I believe that he's going to complete the probation successfully, and just ask that you follow these the terms of the plea bargain agreement. He works as a project superintendent for a construction company.
All right, Mr. Martinez.
Yes, Your Honor.
So you previously had another assault case out of County Court 7 with Nancy Martinez. Was that your wife?
Ex-wife. Yes, Your Honor.
Okay, and I'm sure you told that judge that not going to be any problems, and I don't see a motion to revoke in that court, so I'm assuming there was no problem. You completed. And now we're back here again, and there's an assault against Carla Garza. Is that your girlfriend, wife? Who is she to you?
My wife.
All right. And what we have here is, according to the police report, her daughter is saying that you were arguing about your children that they have with other people. And then you got angry and you punched your wife, whom I'm assuming you supposedly love, in the face twice, causing pain, and that her mouth and nose were bleeding. So why do you have anger issues? You're a grown man. Why do you feel the need to solve your issues with women through violence?
There's no good reason, Your Honor.
I mean, well, there has to be a reason. I mean, why is your go-to? I'm in an argument. Maybe you're losing the argument. Who knows? I wasn't there. And your go-to is to hit someone. Why is that your go-to?
No explanation, Your Honor.
Well, I mean, he needs to figure out why that is his go-to, because this is what's going to end up happening, Mr. Martinez. The same thing that you told the judge in County Court 7, saying, I'm going to be just fine. I'm going to follow you. You're not going to have any problems with me. Sure, you completed probation successfully because people were watching you. And then what happens? You get in an argument with your new wife, and you want to solve that by violence. Do you even realize the person who came and reported this? I believe it was her daughter, Camilla. And is Camilla your daughter too?
My stepdaughter, Your Honor.
All right. So can you imagine her seeing that you're supposed to love her mom, and here you are punching her in the face? And what that does to her psyche? I mean, do you even realize the drama and trauma that you caused her?
I realize, Your Honor, and it's not, I take full responsibility. And
I mean, we say that, but do we really do? Because the thing about it is, when you take responsibility for something, then hopefully you would do an internal evaluation of why you behave the way you behave, and you won't do it again. So that's a problem. I mean, I'm going to go along with your application for probation. I do believe as proven in the past, he will do well on probation. And this is the agreement you have. So I'm going to go along with that, but you need to start doing an internal evaluation of yourself to find out why your go-to, unless somebody is supervising you, why your go-to is to hit somebody that you claim you love. Usually what people say is if you're in a relationship and it gets to the point where people want to put their hands on each other in anger, maybe you shouldn't be in that relationship. And it's not saying it's her fault or your fault, but when you're in an argument and your go-to is that's not a relationship you should be in. Now, can someone talk to me about why she wants to have contact with him?
Judge, they're married, and obviously it's been difficult with him out of the house with the children and everything like that. We did have a motion this was previously, I believe it was back in August, to change that from a no contact to a no injurious contact. She signed an affidavit. She came in on Zoom, but I think it was just because it had been such a short time, you didn't grant it at that point because it was, I guess, so soon after the incident. So more time has passed now, and that's her same stance. So we just ask that you follow it.
Right, this is what the court is going to do. The court will follow your agreement. The court will sentence you to 4 years in the prison, suspended and probated for 4 years. There's a $1,000 fine that will be probated. There's an affirmative finding of family violence, $100 to a family violence center, the BIPP course, 80 hours of community service restitution. 40 of those hours will be waived if you provide proof that you completed the COVID vaccination regimen. There's to be no contact with Carla Garza. The court will, of course, reconsider the no contact order, Mr. Navy, once he's had at least three BIPP courses. And if he can internalize to me, why is his go-to to hit somebody? Because until he understands why he does that, he's just going to repeat it. So there's to be no contact with Carla Garza, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I want field visits, 1 time per month, random. If you're drug tested today, what are the results going to be, Mr. Martinez? Here's the thing, be honest with me.
Yes, Your Honor. In Christmas, smoked weed for maybe the 2nd time in my life.
I'm going to want random UAs. And Rebecca, if he's positive for marijuana, I want him tested for levels. And I'm going to want parenting classes. You must complete the parenting classes, and they're going to be with compadre y compadre. And if he completes the parenting classes, then the court will waive the remaining hours of community service restitution. Rebecca, is there anything else he needs?
No, ma'am.
Mr. Martinez, is there anything else you need from me in order to be successful?
No, Your Honor. Appreciate everything, Your Honor, for giving me this opportunity.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your, did you understand because you signed that and because I thought, thank you, Brenda, I see the laughter. People are tempting me with chocolate back here. I'm not going to eat it. It's like they're coming by and they're dropping off chocolate. And I'm like, no, thank you. So, Mr. Martinez, because I followed your plea bargaining agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, Mr. Martinez, we're going to go off the record. Good luck to you. Make sure you follow all the rules and start really thinking about why you behave the way you do.
Yes, Your Honor.
Okay. I'm going to send you to breakout room number 1. And Mr. Navy, could you wait in number 1 with your client just briefly?
That's fine, Judge. And so, and just to clarify, once he completes those 3 classes,
Then come back and bring him back. But
okay.
Mr. Navy, he needs to be able to tell the court why he behaves the way he do.
Okay.
All right. I'm going to send you to number 1. Sorry, the reason he behaves the way he does. All right. Who are the parties on Rivera? Yes.
I'm present. And my client's here, there.
All right, I put him here. All right, Mr. Martinez, you need to go to breakout room number 1.
Yes, Your Honor. Trying to see if I can get that option. It's not popping up on the screen.
All right, I'm going to show you where I put you in 2, and then I'm going to put you right back in 1. All right, the court is calling 2021 CR 0019W, State of Texas versus Angison Enrique Rivera. Can I have parties announced for the record, please, for the state?
Ryan Groomer for the state of Texas.
For the defense?
Gail Calderola here for Anderson Rivera.
And are you Angison Rivera? Can you unmute for me, please?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
None from the state, Judge.
Any objection from the defense?
No, Your Honor.
Mr. Rivera, I'm showing you a document entitled Defendants Consent to Appear by Video. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney and did you understand it?
Yes, ma'am.
Are you the same Angison Rivera who was placed on deferred adjudication in cause number 2021 CR 0019W for the offense of possession with intent to deliver a controlled substance penalty group 2, 4 to 400 grams on January 11, 2021? Is that you?
Yes, ma'am.
Date?
Yes, Judge. We have a condition. Can I read the condition to the court at this point?
Yes.
Okay, Judge. Violated condition number 2, that on or about the 12th day of February 2022 in Bexar County, Texas, the defendant Angison E. Rivera did then and there illegally use a controlled substance, namely cocaine, in violation of condition number 2.
How do you plead to that, true or not true? You're on mute, sir.
Guilty.
No, it's true or not true?
Oh, true. Sorry, ma'am.
That's okay. State?
Judge, we'd waive the remaining conditions on the motion.
Any objection to the state's waivers?
No objections, Your Honor.
Mr. Rivera, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to life in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
There is, Judge. We have an agreed recommendation to make the court. We'd ask the court to deny Mr. Rivera's motion to enter an adjudication of guilt. However, to alter and amend for a referral to the felony drug court and to have the judge make that recommendation in consideration for him pleading true and his being referred to that court, we would TIC a new number 1 case under case number CM 93317 and also JN 2046710. Judge, it'd be the state's recommendation if for whatever reason he's denied from felony drug court that he be given SATF.
All right, Ms. Calderola, is that your agreement?
Yes, that's my understanding, Your Honor.
All right, thank you. Mr. Rivera, are you asking the court to follow that agreement?
Yes, ma'am.
All right, the court will follow your agreement. The court will deny the motion, alter and amend conditions to include a referral to felony drug court, taking consideration CM 93317 and JN 2046710. You to remain in custody until accepted into felony drug court or transferred to SADF. Rebecca, the first thing I want is for him to be considered for felony drug court. And if he's not accepted in felony drug court, then referral to SADF. Mr. Rivera, if you're honest with felony drug court, then felony drug court will accept you. If you're not honest with them, what they're going to say is, he said he doesn't have a drug problem. And we all know that you do. You understand, Mr. Rivera?
Yes, ma'am. I know I have a drug problem. I know I gotta do better for my life and not mess up anymore.
All right,
This is the place that I will be if I keep on messing up.
All right, so we're going to go off the record. Brenna, it's court reporting day, and I promise you that you will be able to leave by 11:45. So thank you, Brenna.
Thanks, Judge.
All right. So, Mr. Rivera, you got to make sure that you follow through on everything, okay? Felony
Yes.
drug court is a very good program. And I'm going to tell you what I tell everybody else. The people who are making these drugs that people ingest, they're not chemists. They're just throwing things together. Sometimes they in rat and roach infested places and just throwing chemicals together because their main concern is, let me make some money by selling to this person who is in throes of their addiction. So I have faith that you can do better. So do better, okay?
Yes, ma'am.
All right, I'm going to send you to breakout room number 1. Miss Calderola, you can go to number 1, or either you can be excused. Thank you so much for your patience.
All right, thank you very much, Your Honor.
Thank you. Everyone else, as you know, they're doing a declaration for court reporters today. The mayor is going to be doing that online. So we're going to come back at 2 p.m. so that they can get that done. And so we don't have a court reporter till 2 p.m. And I think you're going to find in other courtrooms that hopefully their judges are giving them a break too. So they can have that from the mayor. Mr. Martinez, are you on iPhone or are you on a Android?
An iPhone, Your Honor.
Tap the screen and it should show where you can go to a breakout room. And that will be breakout room number 1. Nathaniel, your client is having a little difficulty getting to number 1.
And do I need to go to breakout room 1?
Yes, you can. And Rebecca, you can go to number 1 now.
Okay, thank you, Judge.
All right, and we're trying to still get your client to number 1.